So there's a few times throughout my blog and bankruptcy.blog that I have to continue to reference a notice of bankruptcy filing or a suggestion of bankruptcy because there is some sort of civil case pending. Doesn't matter whether it's a car repossession, foreclosure, or a credit card company that is now suing you in order to gain access to freeze your accounts or garnish your wages. So I've done a blog post on that, and of course I go back and like happens all the time. That screenshot that I posted no longer works for whatever reason. So I decided it was just easier to just do a quick video. So in this video, what you're looking at is that I just looked up one of my old cases. When you file for bankruptcy, there's going to be a link in on the court website, and I'll link it to pacer.gov, which shows you how to, enroll in the system and everything. I did a separate video on that before where it's going to prove that a bankruptcy was filed. And all we call that is a notice of bankruptcy or suggestion of bankruptcy. So you see here all the case information. I'll put here the name of the debtor and everything else, and of course, what district. Now, the problem is you need to file that with the civil case, whether it's to stop the foreclosure, car repo, or the credit card lawsuit. So just filing for bankruptcy, yes, there is the automatic stay. But if that creditor isn't noticed or the court, then these issues are going to continue. So that's when it comes with filing this notice of bankruptcy with the state court. Now, I'll put a quick, I'll show you the actual form that I use, more or less zero. So I had to make a second video so I can go ahead and jump over to this screen. But this is the notice of filing that I would do, and that's enough to stop any lawsuit. As you can see here, I mean, you just have the creditor information, whatever bank, Bank of America, Capital One, whoever initiated the lawsuit, your information, which you're the defendant, and then, of course, where this case is pending. And so the notice of filing, just like any other pleading gets done, you're going to say that a suggestion of bankruptcy is being filed in this case. You make sure you serve everybody with the lawsuit. And then, of course, it gets filed with the clerk's office where that lawsuit is pending. That will stop the wage garnishment and everything else. And at this point, if by and sometimes it happens by mistake. If by any it happens by mistake that the creditor, had already submitted. Remember, sometimes pay stubs are done way in advance for large companies. So even if this gets filed on a Wednesday or Thursday with your paycheck coming in on a Friday, it's possible that the wheels were in motion. It couldn't be stopped in time. Doesn't matter. You have proof that you filed the bankruptcy. You have proof that you filed a suggestion of bankruptcy with the civil court. And again, mix up and miscommunication, but there should be no issues in getting the funds back from the plaintiff or the creditor. Of course, if they don't for whatever reason and they refuse, which I've never seen that happen before, then the answer is simple. You just go back to court, seek sanctions, prove that everything was filed timely, and then the court will take it from there. Okay. Any questions or comments, feel free to let me know and post them in the comment section below.